Hello, everyone. We're going to go ahead and get started. Welcome to today's webinar titled Estate Planning Truths, Estate Planning Blunders You Cannot Afford to Make, and Debunking Estate Planning Myths, presented by our Estate Planning Department partner, Paula Clarkson Chamberlain. Just a brief reminder, our law firm, Merhab Robinson and Clarkson, we handle all sorts of estate planning and business law. Um, as you can see, estate planning, probate, trust administration, entity formation, employment law, all sorts of things here. So if you ever have any sort of estate planning or business needs, feel free to reach out to us and we can help. Our presenter today is Paula Clarkson Chamberlain, as I said. Paula is a founding partner and the head of Merhab Robinson and Clarkson's estate planning practice. She primarily practices in estate planning, probate, trust administration, and conservatorships.
Thank you, Avalon. Let's get started with some common blunders that people make with regard to estate planning. So the first one is lack of healthcare planning. We see that most deaths occur in the hospital and other healthcare facilities. And if someone does not have documents to decide who gets or who makes their medical decisions, what type of medical decisions, then the family as well as the medical providers can be without any direction or authority. So the healthcare directive is the way to take care of that. By completing a healthcare directive, you're designating who makes your medical decisions for you when you can't, as well as what end of life donation of organs, disposition of your remains that you want. So having that will help you avoid that blunder. The second part of that tags on is having a HIPAA release. A HIPAA release just says who has the authority to talk to your doctors and get medical information. So a lot of times people will assume that their spouse or family members can, but we've had a number of clients where their spouse has been in the hospital and the doctor will not talk to them. So it obviously is a rule, and maybe not all medical providers are following it, but that is not the time to be figuring it out. We've even had one of my partner, Marla, her son was in a motorcycle accident, was in the hospital, and because he was an adult, and at the time she did not have a healthcare directive or HIPAA, she was unable to get medical information on him until he became conscious a couple hours later and was able to speak to the doctors and give the authorization. And that can be a terrible few hours when your loved one is in the hospital. So making sure that you combine the healthcare directive as well as the HIPAA are very important to avoid these blunders. Our next blunder is failing to appoint a financial decision maker. So we want to make financial decision makers available if you are unable to manage your affairs or when you pass away. And the financial decision makers can be done, primarily in a power of attorney, a trust, a will, so that they can provide it while you're alive or upon your passing. And it could be something as simple as paying your bills and while you're alive, or canceling things after you're gone. A lot of our clients will come in and they say, well, I just put my son or daughter on my checking account with me. And we really don't recommend that, because by doing that, number one, you're exposing your assets to your creditors of your child. So if you are a joint owner listed with your client, your son or daughter, and they get sued or they don't pay bills, and their assets are attached, then they're on your account. So your assets are attachable as well. And it's not 50%. They can go up to the whole account. So the better way is to use the power of attorney or a trust while you're alive to give them that fiduciary power to make your financial decisions. And that way their personal creditors can't get to it. The other downside of doing that, naming a son or daughter on your account, is that by operation of law, if they are a joint owner on the account, if you pass away, they automatically get that account. And we've seen some children that have been in that situation say, you know what, I know I was only on there for signatory purposes. This is really part of mom and dad's estate that should be divided to all their beneficiaries, and some children that are not, and they keep it all. So depending on what your goal is, that's a blunder to look out for on how you're taking care of it. So we recommend that you do it a formal way with a power of attorney or trust, to put them in a fiduciary capacity. Our next blunder is not having any will or trust. So that then has a problem of, where do your assets go when you pass away? The first one, if you have nothing in place and your assets exceed 208,500 in California, they can be subject to probate if they don't have a beneficiary. So normal things that have a beneficiary, like retirement plans or life insurance, usually will pass automatically. But if you have a house, bank accounts, things like that with a combined value of 208,000, then they can be subject to probate. And without a will or a trust, the state of California has a plan for where your assets go. So we recommend that you do put a will and trust into place. There was a law change in April of this year in California that if you have only a residence and it's less than $750,000, then we can do a shortened version of probate, and it's supposed to help people. But we're still seeing, on the couple we've filed thus far, the hearing dates are still being set out 3 or 4 months. So that means that there's 3 or 4 months without anybody having authority on that property, without potentially the heirs having the money to be able to, or the authority to sell the property, and access the cash and everything like that. So number 5 is forgetting about your digital assets. In this day and age, your digital assets are so important. We all have email addresses. Oftentimes we're getting e-bills. You're having notices. You have photos. I mean, if anything, some of us have, social media accounts. We have blogs or, YouTube pages and things like that. And some of those earn money. So it's really important to make sure that you're taking care of those, and that your digital assets are taken care of and provided for. And we usually assign those to your trust. Another thing to look out for is on your social media accounts, there's often a beneficiary that you can name. I know Facebook has someone, and naming someone on LinkedIn, so that if you do pass away, that they can close your account or they can download those photos. And each social media account has their own version. So usually you can find that in your settings. I think Facebook calls it a legacy person to take care of things. So those are always important. We do include in the power of attorney the language to be able to take care of your digital assets, but we like to assign them to your trust as well, especially if you're in a position that they're making monetary value. Failing to anticipate issues with your children, future lawsuits, creditors, divorces, and things like that. When you're doing a trust, you have the ability to give them some protection. So if you don't, then you could potentially give them their assets. And then, if you have a child that is in a career that gets sued a lot, maybe a physician, someone that runs restaurants, most restaurants fail. So if your child received an inheritance and it's now in their pocket, and they have a bankruptcy because of a business or get sued personally, then they could unintentionally lose the inheritance as well. So trying to think about, what their situation is would be a good way to provide them protection on a go-forward basis and look at those things. If you want to make sure that they don't share the inheritance, which is separate property, with their spouse, there's ways that you can keep it from their spouse through your trust. Instead of leaving it outright to them, you can leave it to them in trust and allow your child to be the trustee or someone else. And then they are prevented from commingling those assets with their current spouse and potentially losing some of that in a divorce. So those are always things to think about depending on your family situation. IRA accounts. These are a big deal. So IRA 401k are great plans that you can set aside money tax free, can grow tax free until you have to start taking your required minimum distributions. But there's a big deal with these because when you pass away, the assets, if you name a spouse, the spouse can roll them over and continue to take them out. So, one thing we need to look at is if you are in a second marriage and your IRA rolls over to your spouse then can name any beneficiary that they want. So, you have to determine first, is that something that you want? Because your spouse may not give it to your children, they may leave it to their side of the family, or if they unintentionally fail to put a beneficiary on their IRA, which we see that a lot, is that the spouses will only name each other and then not somebody else. So if the wife had, like, if the husband died, left his IRA to the wife, and now the wife just rolls it into hers, but she had only had the husband as a beneficiary, when she dies, the IRA will go through probate. And the probate generally goes to her side of the family, depending on what her will says. So that's an important thing. We also need to think when we're looking at any beneficiary who's not your spouse, the general rule is that they have the option to take the money out anytime they want within 10 years. So a lot of times the beneficiaries will take a lump sum right when the parents die. And the child will then be subject to income tax on it, usually 20 to 30%, depending on their own tax bracket and how much they're receiving. And that might not be something that you want to happen if the child is one, if they're a minor. We want to make sure, because if they're a minor, they can't do that. We'd have to have a guardian of the estate opened up and the court involved, which is not a good thing. But then when they're 18, they would get control of it. So I know I have a 19-year-old. I would not want her to be able to access and decide a 401k. It makes a difference too. If there's $20,000 in it, she takes a lump sum, who cares? But if there's 200,000, 500,000, some of our clients have up to $1 million in their 401ks or IRAs. That could be a substantial amount, and you have to look at the beneficiary's age and situation to determine if it's good for them to make the appropriate decision or if you're comfortable with that. There are ways that you can protect it by naming your revocable trust, but there's special ways you name it. You don't just say, for example, the Smith Family Trust. It would be the Smith Family Trust for daughter Smith, and things, and there has to be certain language in your trust. Or you can also some clients will do a completely separate IRA trust, and it allows you to have those assets go into that trust, even if they are paid out over the 10-year period or a lump sum is taken, but the beneficiary does not get all of that money. So it's kind of a step in between of them getting control. Because you can imagine if you had a beneficiary that maybe had some addiction problems, that leaving them, a $200,000 IRA may not be safe for them. And we'd want to leave it somewhere else. And so we have to basically weigh the tax implications as well as the control implications. So these are very important decisions to take a look at, and not just knee-jerk naming spouse and kids. Chaotic record keeping. If you have ever had to take care of an estate or parents who are now incapacitated, it's hard enough for us all to deal with our own paperwork when we're dealing with tax season, let alone stepping into someone else's life and trying to figure out what property do they own, what retirement plan, what bank accounts and everything like that. So for the sake of your loved ones, keeping things organized, keeping a list of what you have. If you have old financial accounts, get rid of them. If you no longer have a certain bank account, you no longer use it, maybe you shred all those papers, because if they're going through your home office or wherever you keep your documents and they come across these statements, they're going to have to go down that rabbit hole to make sure that nothing is still there. It's always a good idea to keep a list of your current assets, as well as who those beneficiaries are. Um, Going back to the IRAs, sometimes, and we'll talk about this a little bit more in the future on other slides, um, some people will name charities as beneficiaries of IRAs, or they'll name other people as beneficiaries. And letting your family know that, having a record of that is really important so that they are not coming across roadblocks when they're trying to marshal your assets after you've passed away. And then going back to the digital assets of what are your passcodes, what are documents. I know I get most of my bills is e-bills, so I either get an email about them or they come into my bank account. So if I were incapacitated, somebody else would not know that unless they had access to my email account or to my bank account to be able to do that. So making sure that those are kind of kept around, passwords to, again, your social media, and things like that, so that people can determine what is there. I even get most of my 1099s and tax documents at the end of the year that are online and through these companies, and mostly being notified as an email. So if someone was walking in and they didn't have access to your email and you are incapacitated, they would have no way to help you, and it would make it very difficult. So making sure that you're keeping things organized for your loved ones when they're going through this difficult time is important. Um, Also, failing to think about if your spouse may remarry or has creditors or people coming after them when you're deceased. So we see this happen a lot, is one spouse will leave all their assets to a surviving spouse, and then the surviving spouse, maybe they get remarried. And if they fail to plan appropriately, they could unintentionally disinherit your children. Um, or if they get married and they fail to do a plan appropriately, where if, let's say that a husband and wife get married, the wife creates her own trust thinking her assets are her separate property. Within her estate plan, there are certain things she needs to do if she wants to disinherit her spouse. Otherwise, the spouse will be considered an omitted heir. I have a matter right now that we're going through some pre-litigation on, and that the husband had created a trust just a month before they got married, saying, I'm planning on marrying this person and I am disinheriting her. I only want her to have these certain things and the rest of it to go to my children. But he did it before they got married. So she may be entitled to a third of the estate more than he had anticipated. And obviously each parts of the family have a different point of view on what the agreement was during their lifetime. So, or even leaving the assets, again, going back to IRAs or life insurance, you name your spouse as the beneficiary, they get remarried. And then the IRA that you have rolled over to them rolls over to their new spouse, or they leave everything to their new spouse. And now the new spouse's children get the assets instead of your children. And then also looking at, are they capable of managing it if you pass away? We have lots of clients that have very, very long-term marriages. And when one spouse passes, the surviving spouse might be in their 80s, might be a little bit vulnerable. So looking to see, do we need to put, maybe one of the children or some other trusted person in place to help them with their financial affairs after one of the spouses is deceased. We also want to look at your personal items. We see a lot of people fight over not just the cash and the stocks, the liquid assets, but things of sentimental value. A lot of times they don't even have a high monetary value, but they'll be fighting over, maybe military memorabilia, photos, different things like that. So jewelry is a big thing. So if there's, if you have an estate plan, we can lay out who gets which items, or we can also include an amendment to your trust called a personal property memorandum, where you detail it over time what you want them to have. Or it's also nice if you're not using certain items, like maybe you're not using a china set or something like that, or a piece of jewelry, that you give it to your children, grandchildren for special occasions, for holidays, so that you can then start to see them use it. The right person has it. Everybody understands you gave it to them because you chose to. And that eliminates a lot of fighting, because we see it a lot where the house is kind of rated by the first person that gets there, when there is some deception in the families. So making sure you're very clear about who gets what, is always a good thing. Because you'd be surprised at sometimes people spend thousands of dollars in legal fees fighting over something that may cost $50 at the store. Little things like pictures, we can always copy, videos can always be copied, but sometimes it's little pieces of things, that have a lot of sentimental value. A big blunder, people assume that once they do an estate plan, that they're done and they never have to think about it again. It's really important to keep your estate plan up to date. At our office, we do reviews with our clients every 3 years, some clients even more than that, based on change of situation. It could be your assets change, your goals change. It could be the family's change. Did your kids get married? Do you have grandchildren now? Has there been any change with regard to some of the beneficiaries? Maybe addiction issues, mental health issues, special needs, that maybe wasn't considered when you were creating the plan. We have a lot of young families come in and create plans. Their children, are under 10, and the way they assume their children are going to manage money may not be the way that the children actually manage the money when they're in their 20s. And sometimes, I joke with clients, but it is a reality. Who is whispering in their ear? So looking at who is their inner circle, who are your children's spouses, and things like that, to make sure that the plan is taking into consideration all the different angles that might need to be dealt with. So there's a lot of, even though people make mistakes, there's also a lot of myths that people believe that are completely inaccurate. So let's go through those. So as I mentioned before, that my spouse can just make my healthcare decisions for me and financial decisions. That is not accurate at all. So as I mentioned before, there are sometimes doctors that will talk to you and won't have an issue with it. But I've seen it with a lot of clients that, regardless of whether they're married or not, the hospital will not speak to you unless you have the proper documentation. We also have issues depending on how you're holding the assets. If a couple holds assets as joint tenants, as their house, husband and wife is joint tenant, and one spouse has, Alzheimer's or dementia, the other joint tenant cannot refinance the house, cannot mortgage the house, cannot sell it. You need to have both parties' authorization, or the party that is incapacitated needs to have a power of attorney or a trust indicating who can manage their affairs. So just being married is not enough to require or authorize people to deal with you regarding healthcare and financial decisions. So as I mentioned more, the spouse doesn't always can do it, and as well as financially to be able to pay bills. Number 2, does your family know your wishes? We have lots of clients come in and say, oh, I think that they'll be fine. But you know what? If you have more than one child, sometimes one of the children doesn't want you to be cremated. Some maybe that child does not want, could never, withdraw life support from you. And if, what your wishes are, you could have told your family a number of times, but if you have people there and you've not given them the authority or detailed what you want them to do, they could be making decisions that are not at all what you want them to make. And it's interesting. People know, because I have a lot of clients that'll say, "Oh, I can't name this child because they wouldn't follow my wishes because they would want me to be buried. They would not cremate me. They would never be able to do end of life decisions and things like that." So it is very important when you're dealing with um, to name the right people to manage your assets and your healthcare decision, as well as detail your wishes so that those rules can be followed. So, because of that, sometimes we have unintended beneficiaries. If, you know, let's say that you had, it was a blended family, one spouse died, the other spouse said, "Oh, everybody assumes the estate will be divided between both sets of beneficiaries." But if the surviving spouse didn't have a will or a trust, then the assets are going to go through probate and they're only going to go to that spouse's children. The other spouse's children could be um, unintentionally disinherited, or the assets could end up with distant relatives and people that you did not want to have the assets to. We have quite a bit of people that come in and say, "Oh, well, I know the trust says this, but my mom wanted these other gifts." And we're like, as trustee, your job is to follow the terms of the trust. If you want to give those people money out of your own share, that's perfectly fine, but you have to go by what is written. So this goes back to keeping your estate plan up to date, so you can avoid family disputes, so that there isn't a loss of control, making sure that you have it written down in a will and a trust to avoid the litigation between the families. Our third myth is, as I mentioned, it's created and it's done and you never think about it again. So going back to, we want to make sure that the assets are in your trust. Our assets change over time. We move houses, we change financial institutions. We want to make sure things are updated. If you move states, you want to look at what the new law is in the state, in your new state, to make sure that your plan still works. For the most part, it probably will, but there are some states that there are different laws on healthcare as well as financial. So it's always important to have it looked at again, as well as any major life events that happen. So those, as I mentioned before, family changes, financial changes, moving, tax law changes, changes in goals. One of the biggest changes that we had this year is starting in January, we can all pass $15 million estate tax free. The way we were doing estate plans, 5 to 20 years ago, often required the trust to be divided when the first spouse died to save estate taxes. That's often not necessary now because the exemption is so high. So it's always unfortunate when the couples come in and we have to explain to them that the trust says that they have to divide it into one, two or more subshares. So it's always important to take a look at it and see if the plan can be simplified or if anything needs to be taken care of based on the change in the asset structure or the laws. A lot of people think that they're not rich enough to have an estate plan. In my opinion, if you're 18 years old, you should have an estate plan. So at the minimum, you start out with when you're 18, and even if you don't have assets over the 208,500 threshold, you should have a power of attorney, a healthcare directive, and a HIPAA. The power of attorney will allow, while you're alive, if you become incapacitated, the agent that you name can get your final paycheck, can apply for Social Security or other government benefits, get into your 401k, things like that while you're alive. Now, if you just go with that and you die, like we use it a lot for college students, young adults. If their assets under 208,000, we explain to them, if it's under 208,000, the heirs at law would first be their parents. If they're comfortable with that, great. We don't have to do a will because we don't have a probate. Once we get over that amount, there's going to be a probate. Once they get married, let's have the conversation. Do they need to do something? Do they have minor children? So depending on the stage in life, we might need to do some planning. And even if you only had 200,000 and you had a 10-year-old, you don't want to pass away without leaving those assets presumably in trust for the minor, because otherwise you pass away, You give $200,000 to a minor, it may not have to go through probate, but what's going to happen is there's going to need to be a guardian appointed because a 10-year-old can't take $200,000. And the court's going to need to oversee that money until your child is 18 years old, and then they get given that money. Now, you might think, okay, they get 200,000 when they're 18, but realistically, it's not going to be 200,000 because the cost of the guardianship, usually about 3 to 5,000 just to get it started. And then year one after the guardianship is open, then every other year until the child turns 18, then they're going to do a final. They have to do an accounting for the court to show that the guardian is not stealing the money. And those accountings usually end up costing about $5,000 to $10,000 in legal fees to put it all together, to appear at the hearings. So when you leave 200,000, you could significantly eat into that by having a guardian of the estate. And we would prefer the money go to your children as opposed to us. So there's ways that we can do that differently through a trust, making it an easy way to do it. Also, with a trust, you can specify maybe you don't want your child to have the money at 18. Maybe you want someone else to continue managing it for them for a little bit longer till they're 22, 25, whatever it might be. And you can do that through a trust. And with the trust, there's options for potentially waiving the accounting or doing an informal accounting that can save a lot of money so that you're not having to incur all those expenses and whittle down what you've left for your beneficiary. So so as we talked about protecting the children, but also naming guardians for them. So even if you have, 50,000, 100,000, 150,000 and don't need to go through probate, and you have minor children, we want to name guardians for your minor children so that you are speaking from the grave of who you want to take care of your children and raise them. Because otherwise, there are preferences that are set out, a priority in the probate code. And I know in my own situation, I'm an only child. So it would go to my ex-husband's family generally. And if he were gone, then his siblings would be first in line. And though just knowing my situation, that would not be a good option. So you always have to think about it's not just necessarily the money. It's protecting the children. We're looking at the pets. It's disposing of, again, we talk about sentimental items if there's other people you want, and the planning for the incapacity. So even if you don't have that, the threshold for probate assets, the 208,000, we usually recommend power of attorney, healthcare, HIPAA. We do that a lot for the young adults. We do that a lot for older parents that maybe not have a lot of assets, that may be just living off of Social Security because Social Security ends when they die, but they still need someone to be able to make medical decisions, to do those financial decisions while they're alive if they are incapacitated. So it looks like we have a few questions. So let's go ahead and get started. If you have additional questions, feel free to throw them in either the chat or the Q&A button. And I'll get started on the first one. It says, are the holidays a good time to have these conversations? If my parents do not have an estate plan in place, they think everything will be fine without doing anything. I think it's a great time because generally all of the family is together and you can have that discussion and talk about what they want and have them formalize it so that, I'm a big proponent of the parents being upfront about what's going to happen because it's when you have the secrecy, then that's when the disputes happen between the children. And when they're grieving the loss of their parents, we're dealing with a lot of mom loved you better, mom, didn't like me, or you took advantage of mom and different things like that. So when the family is together at the holidays is a great time to talk about that, make decisions about, maybe who should be in charge if mom and dad are incapacitated. Sometimes it's, if one child lives close to the parents, that's probably a good person to be the healthcare decision maker. Because they're the ones that are able to go to the doctors. If parents need to be moved to assisted living, they're the ones that are able to see them on a regular basis. Having the discussion, are you splitting up the duties of who's doing financial, who's doing the healthcare, and talk to the family members, or what member of the family. There's 3 children, one of them may be too busy to do it, depending on their own life circumstances. So yeah, when everybody's together, it's always a good thing to do. Do we need to tell all our children the details of our estate plan? That's the second question. I mean, if you're doing something out of the ordinary, I would have a discussion, because we have clients that will disinherit their children or leave them less for specific reasons, or say a child works in the business, they may leave the business to that child and leave other assets to the other children. I mean, having the discussion with the other children to say, these are the reasons why I'm doing it, is a good thing. I know in some instances it's maybe not safe or not prudent, but generally being open and honest about what your plans are is a good thing to prevent disputes and misinformation or misunderstanding at a later date. The next question says, how do you recommend parents with young children plan for them to receive their inheritance? They're too young to know financial readiness and total estate value when we die. That's where I would recommend you have a trust and leave the assets to the children in trust. And, at least until a higher age, I usually think, maybe 25 to 30 is a good time. Let the kids come out of college or at least start working by then. And it's hard when you have really young children. You're going to assume that they're going to be financially literate, but it's a good idea to allow someone else to manage it for a while, and then revisit it as you get older and the kids get older. I say, we have parents come in with children under 5, and I would think they probably wouldn't make a lot of changes until their kids get to be their late teens or in their 20s, where before they may have left it in trust. But when they see that they're in their 20s, they're financially mature, depending on what their situation is, they may decide, okay, I don't need to have it managed for them until they're 30. They can handle it themselves. There are some of my clients that think that their children at 18 are financially mature. So I think that's something that you have to look at periodically. I think you plan for the worst when your children are younger, and then revisit it over time, just in case for some reason both parents were not there to help them. And the next one says, my parents have a trust in place. However, recently my father passed away. Sorry to hear that. And my father wants to keep the trust in place, but should she get the trust updated? I'm sorry, my mother wants to keep the trust. Yes, to have the trust reviewed, because like I had mentioned before, some of the trust will say when the first spouse dies, the spouse or the trust may be required to divide into subtrust. The surviving spouse may have the option to divide it. There are tax consequences to those for the remainder beneficiaries. So it's a good idea to take a look at those. Also, with the exemption being 15 million, a lot of people aren't subject to estate tax, but we have another thing called portability, where if in this situation, if the husband left everything to the wife and their estate was close to the 15 million exemption, we can share the husband and wife's exemption, effectively giving the mother a $30 million estate tax exemption. It's called porting the exemption over, portability. It also is a nice cushion should Congress decide to take away the 15 million and reduce it. If you felt comfortable at an estate, that was close, and say, hey, I have lots of cushion, I'm never going to get to 15 million, but then Congress changes the law. So yes, I think it's a good idea always when a spouse passes away to double check what the trust says, see if there's anything that needs to be done. If anything, there are things that need to be done, like valuing the assets so that you can get the basis adjustment, which can help the surviving spouse a lot with capital gains. So looking at it's always a good thing. There may be very little to do. There may be more complex things to do, but it's better to at least have the option and know what you're dealing with. The next question says, you mentioned 3 things a person who has assets under 200,000 should have in place: the HIPAA, the power of attorney, and the advanced healthcare directive. Yeah, and it says, I have 2 young adult children who are just starting their careers. Yes, healthcare, power of attorney, and HIPAA. We've had this happen multiple times just in our office alone. I mentioned my partner. We've had other attorneys and staff that someone in their family was in the hospital, and because they were adults, that the doctors would not talk to the family members without the documentation. And that's not the time to ever figure it out. Those documents are revocable. So as those young adults get into relationships, serious relationships, get older, they can add on to their plan. They can always revoke the plan, amend it to maybe name their spouse as opposed to their parents as their decision maker. So that's just the part of it grows with you and your situation. So um, it looks like there's no other questions. So we have another webinar coming up soon. We're going to skip December for the holidays. And in January, we're going to start again with getting back to basics. On January 21st at 12 p.m., we will send out a blast as a reminder. And it looks like, sorry, we got one more question. Oh, it just says thank you. So thank you for all attending. We hope you have a wonderful holiday season. And if you have any questions, please let us know. But we will be sending out a link to review this webinar again, as well as we post this and other webinars that we do on our website and on our YouTube page. Thank you all very much.